Remember when arguments were made before the Supreme Court both for and against the constitutionality of what is known as ObamaCare? You probably heard much of the screeching and shouting about this topic in the news. But I would like you to think about something that you probably didn't hear and maybe haven't thought about concerning this issue and other issues that come before the Supreme Court. No matter what opinion the Supreme Court issues in this case or in any case before them, that decision does not have the force of law. Though a Supreme Court ruling is not unimportant, it is legally binding and enforceable only with respect to the parties in this particular case. That means it doesn't affect anyone else. It doesn't become law. With respect to the particular parties involved, it's a ruling. But with respect to the rest of the world, it's just an opinion. Here's the important implication of that truth. The governor of each and every state retains the full right and duty to determine whether or not the individual mandate within ObamaCare complies with the U.S. Constitution. Indeed, each governor should determine whether or not the whole scheme of ObamaCare complies with the Constitution, rather than allowing it to be accepted as law in his or her state. I believe that all the fanfare and all the radio and TV coverage is a lot of smoke, designed to convince you and me that the Supreme Court is the great and powerful Oz, and that it is the final arbiter of the constitutionality of the matter, and indeed, of all the matters in the country. But if we look behind the curtain, we find that this simply is not true. Why am I so sure of this? I read the Constitution. So can you. This is Michael Anthony Peroutka for Institute on the Constitution, bringing you the American View.